Hi Graham, thanks for joining us for this discussion about employment law, and we're going to be talking about businesses and small businesses in particular, and some of the issues that they might come up against. What kinds of issues do you think that employers can face?
Well, I guess you get the worst case scenario for most employers, and certainly most small employers, and that's either a tribunal claim form lands on the desk, or a county court claim form lands on the desk, or God forbid, a High Court writ lands on the desk. In other words, litigation has started.
Right,
They need to act quickly, and they need to act fairly decisively. I suppose the next worst outcome from an employer's point of view after that is possibly a grievance that an employee may lodge. Or perhaps even a question and answer document in relation to potential discrimination claim, which can be equally scary as far as an employer is concerned. And then the other types of situation where you'll get a small employer across the door is if they're made aware of a change in legislation, they've heard something on the news, and they want some advice. The other hot one is advice on handling disciplinary issues. They've got a problem with an employee, and they want to know how to handle it in the correct way. So I would say they're the main areas.
Yeah. Are there any, within those kinds of situations, do you see businesses who are totally unprepared for them, or are most businesses sort of tried and tested with the way that they approach things, or do you see the full range?
You see a full range. I mean, we deal with a combination of employers. You can be dealing with relatively large employers with HR departments, or if not HR departments, well-trained individuals who've got an awareness of personnel and employment law. It's a wide variety. But that's what makes it interesting. Being an employment lawyer, you've got different categories and different types of employer walking through the door all the time.
Yeah. So when those types of situations that we mentioned at the start, when they start happening in a business, and perhaps the owners are thinking, what on earth do I do? You know, if it's a new situation with, the court papers have been served, or it's escalating on. What would that look like in terms of finding out what options are available to try to manage the situation?
You'll get a lot of employers, as I say, with HR departments or with in-house expertise, and they will invariably be the first port of call. You will then get the DIY business who may do a little bit of Googling, they'll do a little bit of internet research, and they'll acquire knowledge and in that respect. Others will pick up the phone, they'll come in and see me, or a lot of employers, if they're switched on, they'll try and find a specialist employment lawyer. And even things like podcasts nowadays. Aircasts run a good series of podcasts that employers
on these kinds of situations,
can listen to, and Aircasts are a fantastic resource for employers and employees. They publish a ton of information on their website, and it's accessible. A layman can understand it. But hopefully, from an employment lawyer's point of view, they'll decide to pick up the phone and come and speak to us.
So lots of options at that point.
There is.
So in terms of the DIY, how easy is that, would you think, particularly if you think about maybe a small business that's maybe not experienced this kind of situation before, how easy do you think it is for them to do it all themselves and to manage that process?
A lot of employers think it's an easier job than it is, and I see this time and time again. It's not uncommon for an employer to pick up the phone and say, I'm a bit of a pickle. I've got this claim against me. I've got to the stage of a hearing.
Oh, right. So they've already tried to fend it off themselves or deal
I've
with
come
it.
before an employment judge. I understood
Yeah.
a little bit about what was going on, but I've been given this piece of paper. I've got to do this, that, and the other.
Yeah.
I've got deadlines, and I need
It's all got
help.
very serious.
It's
and-
got really serious.
Yeah.
And inevitably there are situations where you think, well, goodness me, if they'd sought some advice at an earlier stage, they wouldn't be in quite the pickle that they are at the minute. I think there's an underappreciation as far as employers in employment tribunal proceedings are concerned about how formal they are. The employment tribunal was always historically and traditionally a fairly informal forum. But with the complexity of employment law growing over the years and the procedures and the standards applied by the employment tribunals, it's no longer something that you can safely dabble in.
Right, okay.
There's often that temptation. Employers may perceive that they can save cost by doing it themselves. Sure. They may feel that they're competent enough to deal with it themselves. Or they may just get too personally involved that they can't see the wood for the trees.
Yeah.
They start something, they don't want to finish it. That's quite often the case. People find themselves in deep water fairly quickly.
Okay. Obviously, these situations, if something's gone wrong in that kind of way, there's stress for the employee, stress for the employer. There's difficulties from both sides there. Do you think there are any ways that businesses can somehow try to avoid those situations in the first place? Have you got any tips for them?
A lot of aggravation can be avoided by employers having appropriate policies.
Yeah.
Again, I go back to ACAS guidance, but they're a great resource in terms of identifying the key policies that any employer needs. You need a disciplinary procedure as a bare minimum.
Right, okay.
It needs to follow the ACAS Code of Conduct as a bare minimum. It needs to be supplemented with a grievance procedure as well. And even more fundamentally than that, and you still see a lot of employers who aren't doing this, they're not issuing employees with contracts of employment.
Oh, wow, okay.
There's still a lot of people working without a contract and without even knowing that they're entitled to a document setting out minimum requirements. Yeah. So following all of that guidance, having the policies, following the procedure, being savvy, getting to know what a good employer should do, you're able to manage a lot of problems. The other thing as well is it's fine having your policies and procedures, but you also need people in your organisation or people you can involve outside of the organisation who can guide you through and implement the policies as well. A policy, it's a piece of paper after all.
Sure.
Unless it's implemented and people understand how it should be implemented, it's worthless.
Yeah.
I see a lot of employers, and I'll ask them if they've got policies, and they'll bring in a huge, staff handbook.
Yeah.
But you start asking them about them, and
not looked at them.
quite often. There's not a great deal of understanding about what they are and what's involved in implementing them.
Okay.
So yeah, they're the big issues to avoid. Just be prepared as an employer.
Yeah, but absolutely. Being prepared. It seems like that's the number one, isn't it, from the outset as well? As you say, those resources. I guess if you're setting up a new business, those are the sorts of things you need to be on.
Absolutely.
Thinking about.
Yeah. And a lot of businesses, when they're getting help in setting up businesses, they will be told, they will be advised and encouraged to have these documents, to have these procedures. But quite a number of them don't follow it.
And then obviously when things go wrong,
Yeah,
that's
where we come in.
Of course. We hear a lot about discrimination and situations where somebody feels they've been unfairly treated, you know, and in a workplace, obviously that can be very serious. From the point of view of the employer, have you got any sort of advice in terms of how an employer should handle that kind of allegation, or a situation where one of their members of staff is saying, I'm being treated unfairly here and it's discrimination? Got any pointers there?
The loud and clear, advice to any employer confronted with a potential discrimination claim is take it seriously. Take it very seriously, because it's a serious issue, first and foremost. But secondly, it's going to involve you potentially in a lot of time, a lot of management time, and it's potentially going to involve you in a lot of cost. A lot of employers that don't appreciate that if they are unsuccessful in an employment tribunal unlawful discrimination claim, then they're potentially liable to pay unlimited compensation. It's a far worse potential outcome financially than an unfair dismissal claim would be, for example, where there's a statutory cap on the amount of compensation that can be awarded. So that's the first point. It needs to be taken seriously. You need to look at your policies and procedures if you have them. Again, if you're a decent employer, you should have policies acknowledging the existence of discrimination in the workplace, or its potential to apply in the workplace, what you will do about it. That will be allied, obviously, to your disciplinary procedure, because the two invariably go hand in hand. You will also, as a good employer, ideally want to be able to demonstrate that you've trained your staff not only on the policies, but just on awareness of what disability is and the importance of
and their rights as a
quality
as a member of staff.
and diversity.
Sure.
And again, that's a big area where I see employers lacking quite often. They've got the policies, they've got the procedures, but they don't do enough to promote the importance of the policy and to train the staff on understanding what it is. I mean, discrimination law is, it's an expanding area. There's now 9 protected characteristics. Traditionally, the legislation came in. There was sex, and there was disability, and there was religion and race. We've now got protection for transgender rights. We've got provision for philosophical beliefs as well as religious beliefs. So it's an expanding area, and it's expanding because it reflects what's going on in society. But a lot of employers, unfortunately, find it too easy not to keep up with that, and quite often it's just pure ignorance on an employer's point of view that exposes them to claims, real own goals in a lot of situations.
So actually, the definite message there is taking it, as you say, taking it seriously as an issue that can't necessarily easily just be resolved at that point. It will require some serious thought. I mean, the general advice to employers, whether they're dealing with a discrimination complaint or any other complaint from an employee or worker, is to try and sort it out informally at first. Classically, all disciplinary procedures will say if you have an issue with your employer, your first point of contact is, and it's usually the line manager. Try and resolve.
And it's to have an informal chat. It's surprising what can be achieved by an informal chat. Quite often an employee just needs the time to offload and to explain a problem. if that doesn't work, that's where grievances come in,
Okay.
which are basically formal complaints. But grievances shouldn't really be, invoked as a matter of course as the first option. They should very much be seen as the second option. That's typically what would happen in terms of the pattern of a discrimination claim. You hear about it, you investigate it, you have a chat, you try and resolve it that way. And if it doesn't, employers should be encouraging employees at that stage to invoke a grievance procedure. What they shouldn't be doing under any circumstances is trying to brush it under the carpet.
Okay.
I've seen employers do that, and it never ends well.
I see.
It usually at that point escalates matters, and then it's the question and answer letter, and then it's the telephone call from ACAS.
Right?
And then it's the employment tribunal claim form, and there we're at the
You're into that
position we
approach.
discussed
I see.
earlier on. Deep water.
And presumably that can happen relatively quickly. What are the timeframes like for tribunals and things like that?
Well, anybody who has suffered discrimination and wants to complain to an employment tribunal has a set time limit.
Okay.
And it's 3 months from the date of the discriminatory act. In order to prosecute a discrimination claim, the employee would also need to contact ACAS within that 3-month period. So that ACAS can try and achieve something called early conciliation. And that's a process by which an independent officer from ACAS speaks to the potential claimant, speaks to the potential respondent, usually an employer, tries to see if some informal resolution can be achieved. And if it can't, ACAS will say, look, we tried, we can't. They'll issue a certificate, and then the claimant will then proceed to an employment tribunal. They get an extra month to enable ACAS to assist them with that process. So from date of discriminatory act to date of tribunal issue can be about 4 months. And then the tribunal are processing claims nowadays in sort of 2 to 4 weeks or so. And then
so not a very prolonged time frame. Actually, think about that.
It can happen. It can happen pretty quickly. And then from there, a contested tribunal claim, you're probably talking on average sort of 6 to 9 months, sometimes longer than that. Very much dependent on workload of the tribunal, whereabouts you are in the country, etc. But yes, that's another thing that employers, I don't think, fully take on board. The speed at which they can be hit with something like this, and they've got to start making decisions.
Sort of thinking still about tribunals and where, sort of, I guess, at the more serious end of a matter like that. In situations where there's been a dismissal, so an employee has been sort of has stopped working for an organisation for some reason, and there's been a process that will have led to that. What are the differences, and what are the things again to look out for from the point of view of the employer with constructive dismissal and unfair dismissal? I hear those terms a lot.
A lot of confusion about constructive dismissal and unfair dismissal. I'll quite often get a telephone call from an employee typically, and they say, I want to make a claim for constructive dismissal. And what they're actually meaning is, I want to make a claim for unfair dismissal. A constructive dismissal involves an employee resigning, first of all. So there's got to be a resignation, first of all.
Something's happened, and
something's happened.
Led to that.
It's a resignation which follows a serious breach of contract on the part of the employer. So serious to justify, in the opinion of an employment tribunal, who will decide whether this was a constructive dismissal, and that's a finding of fact that they will make, that employee really had no other option. Anybody in the opinion of the employment tribunal, it would be, would have done exactly what this employee has done.
I see. So the conditions were so bad potentially.
The employee's conduct was so bad.
Yeah.
So it's a breach of contract on the part of the employer that you need to show. Now that can be a breach of an express term of the contract. So if I'm your employer and I suddenly impose a pay reduction on you, that's a breach of the contract, because the contract says I pay you X amount and I'm changing it.
You fail to uphold that condition.
Or I demote you because I just feel like it and I've not gone through any disciplinary process. But in most cases, certainly in my experience, the breach arises not from breach of an express term in the contract, but breach of an implied term. Now, the law implies a number of terms in every employment contract, and the one that's usually invoked by employees in constructive dismissal claims is the implied duty of trust and confidence.
Oh, okay.
You get a lot of claims which are run on the basis that the employee has behaved in a way where they no longer feel that they've got the trust of the employer.
Okay.
Typically, somebody alleges bullying or harassment or discrimination. The line manager doesn't speak to them. They lodge a grievance. The grievance is ignored, or there's a delay in the grievance. And the employee gets to the position where they're thinking, goodness me, I'm on my own here. I've got no support. They then walk and they then pursue a claim for constructive dismissal. The claim is always or usually run as an unfair dismissal claim. There isn't a statutory right to pursue a claim for constructive dismissal. Constructive dismissal is just the means by which the employment relationship has come to an end. It's the employee putting themselves out of a job rather than the employer terminating the employment. So it's an unfair dismissal claim. Most constructive dismissal claims are pursued as unfair dismissal claims, and sometimes claims for breach of contract as well. Because if you're going to resign without notice, your employer hasn't provided you with notice. It's kind of odd conceptually, but you usually find that those two claims are run in tandem.
Interesting. Those kinds of situations with some sort of dismissal, how does that interplay with a redundancy situation? Are the issues that an employer might face totally different if they're having to, I don't know, reconfigure the business maybe, and will it involve a change in terms of numbers of people, or the workforce would be different? Is redundancy a formal process in that way? Are there different considerations?
I mean, redundancy, first and foremost is a potentially fair reason for terminating an employee's contract of employment, as is conduct and somebody's performance. Redundancy is a fair, potentially fair reason for terminating employment. However, a lot of people succeed in pursuing unfair dismissal claims based on redundancy. Quite often, and more often, in fact, on the basis that the employer hasn't followed a correct procedure in going about making them redundant. If you're an employer and you want to make one or more members of your staff redundant, you need to warn them, first of all, that the jobs are at risk. You then need to consult with them, which involves sitting down and talking to them about how the situation has arisen, providing the explanation from the business's point of view, allowing them to answer any questions or to challenge any of the assumptions that you may have made as an employer.
Yeah.
It's got to be an active and a two-way process consultation. So that's the second stage.
Yeah.
And then once you've consulted, you've then got to make your decision, which is you're redundant. A good employer, and again, if they're following ACAS guidance, ought to allow an employee who has been made redundant to challenge that decision by way of an appeal.
Right, okay.
It's not an automatic right to appeal a redundancy dismissal, but best practice dictates that you do.
Okay.
And then if that doesn't succeed in a change of heart on the part of the employer, the next option is to contact ACAS and then to begin a claim for a redundancy unfair dismissal.
And it can then route back into that, the formal route. Then.
It can.
Okay.
Redundancy dismissals in situations where there hasn't been any failure in terms of warning and consultation, etc., can be difficult claims to run because the employment tribunals are usually fairly reluctant to interfere with an employer's decision on whether a redundancy situation has arisen in the first place.
Okay. Yeah.
A classic redundancy situation would arise if your business is planning on closing, or you're planning on closing one of your offices and you've got multiple offices, and everybody goes, the business shuts up shop. It's a redundancy situation. If you're unfortunate enough to go under financially, a redundancy situation arises. But a situation can also arise, a redundancy situation can also arise if you just need fewer people in the organisation, if there's a need for a reduced head count. And a lot of employees fall into the mistake quite often of thinking, well, the business is doing really, really well. How can it possibly be making me redundant? Well, the reason is that it's permitted within the statutory definition. So, as I say, in practice, both from an employee's and an employer's point of view, the unfair dismissal claims tend to be based on lack of warning, lack of consultation. Sometimes also how an employer approaches the decision on selection for redundancy. So you may have a situation where an employer
it can be quite difficult, right?
Has a number of employees. It has, for example, say 10 all doing the same job. It needs to get rid of 2. How do you go about deciding who stays
what does that decision
and who goes? And that's where you get into selection criteria and making sure they're fair, making sure they're non-discriminatory. And so you sometimes get claims based on that. My employer didn't apply a fair selection process. It had made its mind up, in other words, and it wasn't going to be swayed by any amount of consultation or any amount of persuasion from me as an employee.
In terms of reaching out and getting help, so for example, approaching you, an employment lawyer, somebody with those expertise actually to guide a business owner through these kinds of situations. What does that tend to look like?
A number of ways of doing it. Recommendation, is always a really good way of finding somebody to approach. At the end of the day, in terms of a choice of lawyer, it's critical that you choose somebody who you've got the confidence is going to get the job done.
It's important, isn't it, to have that trust?
And they're going to do it properly. Anybody who's choosing a professional service wants to be assured that they're going to the right person, and recommendation is quite often a good way of doing that. Word of mouth is good. You can use the internet. There's an awful lot of review forums nowadays. You can see what other people are saying about lawyers. You can contact the Law Society, who will be able to identify solicitors local to you who have expertise.
Okay.
And you can also contact the Employment Lawyers Association. I'm a member of the ELA. And the ELA is basically an organisation which is run to promote excellence in terms of delivery of advice in employment law. So every lawyer who's a member of the ELA, commits to that. So that's another good pointer. And then once you've found the lawyer, meet them. I mean, most employment lawyers and certainly most ELA members will quite happily provide you as an employer or an employee with an initial free consultation.
Chance to meet, to share a bit of information between.
Exactly. It's a two-way thing. You've got to have the confidence of the client and how they're going to achieve that. They're not going to achieve that necessarily, on a first appointment. That they're going to be expecting to pay for a service. They're going to have concerns in the first place about how much the case is going to cost them.
Of course,
So you're not going to help them by charging them for that initial consultation. So you will get some initial feel, I think, and information as well. From the lawyer at that consultation.
Okay.
And if you then decide that you're going to commit to the instruction of the lawyer that you've seen, you really need to ask them what they can provide, what to expect from the service. You need to know how much it's going to cost you, whether you're going to be paying the lawyer on an hourly rate basis or whether you're going to pay him on a fixed fee basis.
So you sort of try to agree as much of that as possible up front.
Absolutely, whether you're going to pay for the lawyer to do all of the job or part of the job, or something we call unbundling.
Yes.
And these are all things that the lawyer should be initiating discussions about, because he knows how it works. You don't until you've spoken to them.
Yeah.
And then the lawyer will typically confirm the instructions in a letter, setting out what the client wants to do, what the solicitor believes is achievable, providing time estimates, as we said before there, because a lot of people have no idea about the time involved in cases, and then obviously giving them the best information about costs as well. It's all part of reassuring the client that they've chosen the right person. And if you don't get that level of commitment, walk away, find somebody else.
Exactly, and choose, as you say, hopefully by doing some of that initial kind of engagement and talking to potential lawyers about the things that they can help you with, you hopefully would get a decent chance of having a good outcome.
You should consider, like any other big purchase, do your due diligence. Go on the internet, find out in the same way that you'd choose your cooker or your fridge or your new car. Do it that way. Same thing.
Okay, brilliant. Graham, it's been a pleasure talking to you today. Thank you so much for all of your insights there. And thank you very much.
Thank you. It's been a pleasure.
Thank you.